Okay, we're going to get started. Tonight's lecture is on direct democracy in California. On Friday, October 31st, we will have the guest lecture from Brandon Castillo from Bicker, Castillo and Fairbanks firm that has run a number of statewide initiatives and referenda utilizing the powers of direct democracy. My intent here is to give the background, the legal landscape of the three forms of direct democracy. Of course, initiative, making laws, referendum, overturning state statutes, and recall, removing officials from office. So let's get started with the initiative. There are constitutional provisions related to voting in this state that are also part of Article 2, but we are focused on the three forms of direct democracy. And the state of California is one of about half the states. About a dozen, 2 dozen of them have the initiative process, the key component of direct democracy. Fundamental to this is the California Constitution statement that, quote, all political power is inherent in the people, unquote. And in fact, the Constitution goes on to state that the government is there for the people's protection, security, and benefit, and that the people retain the right to alter or reform government when the public good may require it. So, starting with initiatives, how are they defined? Well, the initiative is the power of the electors to propose statutes and amendments to the California Constitution and to either adopt or reject them. An initiative measure can be proposed simply by paying a $2,000 fee and presenting the draft to the Attorney General. Ultimately, once that title and summary has been received, it is then presented, the petition, to the Secretary of State. And that petition sets forth the proposed statute or amendment to the California Constitution. And it has to be certified by the Secretary of State through the local registrars of voters in the 58 counties to have been signed by electors equal to at least 5% in the case of a statutory initiative or 8% in the case of a constitutional amendment of the votes for all the candidates for governor in the last gubernatorial election. The Secretary of State then submits that measure at the next general election that's held at least 131 days after the measure qualifies, or at any special statewide election called by the governor that's held prior to the next general election. Note here that an initiative by the people appears on the next general election ballot, not the primary ballot. Only the legislature today can place a measure on the primary ballot. That was changed about a decade ago by statute, where the legislature limited citizen-derived initiatives to appear only on the November general election ballot. An initiative, remember, that is also subject to the single subject rule. So just like in Article 4 dealing with the legislature and bills or legislation to create statutes, those are subject to a single subject rule. So too are initiative measures. And in fact, what it says is that an initiative measure embracing more than one subject may not be submitted to the electors or have any effect. So that language gives rise to what we call pre-election or post-election legal challenges. So in some cases, pre-election, a successful single subject challenge could result in the measure not even going before the electorate, despite having collected signatures. Or somebody could challenge it post or after the election, in which case it could not ever go into effect if the courts determine that it violates the single subject rule. The Constitution also speaks to some prohibitions, and specifically, an initiative measure cannot include or exclude any political subdivision of the state. That's a local government. the 58 counties, for example, from the application or effect of the ballot measure's provisions based upon the approval or disapproval of the initiative measure or the casting of a specified percentage of votes in favor of that measure. And so, in essence, this is an effort to say that, for example, if a county voted against a ballot measure overall, disapproved it, but the rest of the state approved it, the measure could not exclude that particular county that disapproved it. In addition, an initiative measure is prohibited from containing alternative or cumulative provisions where one or more provisions would become law depending upon the casting of a specified percentage of votes for or against the measure. So, what's the process? Again, proposing a statutory initiative or a constitutional initiative is done by presenting that petition, and it includes the text of the proposed statute or statutes in the constitutional amendment. Before the circulation of an initiative petition to gather the requisite number of signatures by California voters, a copy of it has to be submitted to the Attorney General, and the Attorney General prepares what is called a circulating title and summary. Now, if the AG determines that a fiscal analysis is necessary, then that measure is sent to the Department of Finance, who is the governor's budget advisor, and the Joint Legislative Budget Committee, or JLBC, of the legislature, requesting DOF, or Finance Department, and the JLBC to do a fiscal analysis. Now, when the title and summary has been completed, which is usually 45 days or so after submission, this becomes the official summary date. The Secretary of State is the one who certifies the petition based upon the signatures being collected. By the way, proponents have 180 days to gather the requisite number of signatures, beginning with that official summary date. Only registered voters in the county can sign in their actual county of registration. Assuming the requisite number of signatures are gathered and those are certified, then the ballot measure is placed on the statewide ballot at the next general election, again, at least 131 days after the measure is qualified for the ballot. An initiative statute is approved by a majority of voters, and it takes effect on the fifth day after the Secretary of State files her statement of the vote for the election at which the measure is voted on. Now, usually this occurs, this final statement of the vote by the Secretary of State, approximately 30 days after that first Tuesday in November. And then the initiative takes effect on the fifth day after that. Nonetheless, the measure can provide, like a statute, that it becomes operative after its effective date. So there may be a delayed operative date, is what the term is. If the if the provisions of two or more measures approved at the same election conflict, then the measure and the provisions of the measure receiving the highest number of affirmative votes prevails. Now, sometimes we have competing ballot measures here in California on the statewide ballot. Also, an initiative cannot name any individual to hold an office or to name or identify a private corporation to perform any function or to have any power or duty. And such a measure, such an initiative, cannot be submitted to the electors or have any effect. So just like the single subject rule, there is a pre-election challenge or a post-election challenge based upon whether or not the initiative is alleged to have violated any of these provisions. I wanted to also cover some of the key cases interpreting constitutional provisions on initiatives. Now, I'm not citing the cases, but to be aware, the first is that the power of initiative is generally absolute. The courts have said that the power vested in the voters to decide whether the legislature can amend or repeal initiatives is absolute, but it also requires a vote of the people. The people can subject that amendment to conditions. The power of the people is very strong. When the people established the legislature in Article 4 of our state constitution, they conveyed to it, as the court said, the full breadth of their sovereign legislative powers. But when they adopted the initiative power, they restored to themselves a shared piece of that power. So the people's initiative and referendum power and the constitutional provisions mandating electoral review of particular actions of the legislature don't prohibit the legislature from using advisory measures, but obviously those have no particular force or effect. In placing two measures for constitutional amendments on the same ballot, this sometimes could violate the constitutional requirement that a vote be held on an initiative at the next general election at least 131 days after qualification. The courts in California have repeatedly said that the provision for initiatives, the making of law by voters of this state, rests on the theory that all power of government ultimately resides in the people themselves. How have the courts distinguished the initiative versus the referendum? They have said that the initiative power is not a corollary to the referendum power in all circumstances. The initiative allows voters to propose new legislation. In contrast, the referendum permits voters to reject legislation that has already been enacted by the legislature and governor. On invalidating an initiative, the courts have said that an initiative measure must be upheld unless its unconstitutionality clearly, positively, and unmistakably appears in the text of the ballot measure. And when an initiative provision is deemed invalid by the courts, that void or invalid provision must be stricken, but the remaining provision should be given effect, assuming that that invalid provision is severable. As I mentioned, we have pre and post election challenges. Pre election challenges to an initiative need not be brought while the petitions are still being circulated. Adopting such a rule, according to the courts, would place an unreasonable and unrealistic burden on those who may wish to challenge an initiative measure, as well as an unreasonable burden on the courts reviewing it. It is appropriate, they have said, to resolve a single subject challenge to an initiative prior to the election when a court determines that the challengers have demonstrated a strong likelihood that the initiative violates the state constitution's single subject rule. Under these circumstances, deferring a decision until after the election not only defeats the constitutionally contemplated procedure, but may contribute to an increasing cynicism on the part of the state's electorate with respect to the efficacy of the initiative process. Severability, by the way, is not available when an initiative measure violates the single subject rule. In other words, the violative provisions take down the entire initiative. They will not be severed. On challenging an initiative's validity, neither the governor, the attorney general, nor any other executive or legislative official has the authority to veto or invalidate an initiative measure that's been approved by the voters. It would not violate the separation of powers doctrine of the state constitution to permit the official proponents of an initiative to assert the state's interest in the validity of the initiative in a judicial proceeding in which its validity is being challenged. In other words, the proponents of a measure, of an initiative measure placed on the ballot, are given the authority to defend the measure's validity in the courts if there's a challenge, assuming that the government, the attorney general, the governor, the legislature, chooses not to go to court to defend the alleged validity of the ballot measure. In an action that challenges the validity of an initiative measure, because the official initiative proponents are permitted to intervene in order to supplement the efforts of public officials, it's appropriate to view the proponents as acting in an analogous and complementary capacity to the public officials. And therefore, they get to assert the people's interest in the validity of a duly enacted law. And California courts, they have said, have an obligation to liberally construe the provisions of the state constitution relating to the use of the initiative power. And this assures that the initiative process is not directly or even indirectly annulled by any action. Once an initiative measure has been approved by the requisite number of voters, the measure becomes a duly enacted constitutional amendment or statute. And once an initiative measure has been approved, that's what we have in effect. On evaluating the constitutionality of a ballot measure, the courts generally don't consider or weigh the economic or social wisdom or the general propriety of the initiative they have said. Rather, they evaluate the constitutionality in the context of established constitutional standards and principles of statutory interpretation. And the courts have repeatedly said that the initiative power in this state must be liberally construed to promote our democratic process. To determine the electorate's intent, initiatives are subject to the same sort of constitutional analysis as statutes are. So, to determine the electorate's intent in passing a ballot measure, the courts generally look at the language of the initiative itself. On the single subject rule and challenges under that provision, the courts have said that an initiative does not violate the single subject rule merely because it amends two statutory schemes. The single subject provision does not require that each of the provisions of an initiative measure effectively interlock in a functional relationship. Simply, it's enough that the various provisions are reasonably related to a common theme or purpose. And an initiative measure does not violate the single subject requirement if, despite some varied collateral effects, the court said, all of its parts are reasonably germane to each other and to the general purpose of the object of that initiative. Furthermore, in satisfying the single subject rule, the courts have said that the common purpose to which the various provisions of an initiative relate cannot be so broad that a virtually unlimited array of provisions could be considered germane and joined in the proposition, essentially obliterating this constitutional requirement. But the court has also said that an initiative may have some collateral effects without violating the single subject rule. So, what is the extent of the people's powers under direct democracy in Article 2? The people's reserved powers of initiative and referendum are limited to adoption or rejection of statutes. The people's powers do not encompass all possible actions of a legislative body. An initiative which seeks to do something that other than enact a statute, such as rendering an administrative decision or adjudicating a dispute, is not within the initiative power reserved by the people. There is no constitutionally protected right to place an invalid initiative on the ballot. Judicial review of an initiative before the petition has been circulated for signatures does not violate the Constitution's initiative power reserved to the people. Now, what's the role of the Attorney General? Despite the court's duty to jealously guard the people's right of initiative and referendum, non-compliance with the Elections Code can result in a measure being disqualified from the ballot. The title and summary of an initiative or referendum prepared by the Attorney General, those are presumed to be accurate, and substantial compliance with the chief purpose and points of the statutory requirements is sufficient for being upheld. So by statute in the Elections Code, the Attorney General is required to summarize the chief purpose and points of an initiative or referendum measure. If reasonable minds can differ as to whether a particular provision is or is not a chief point of the measure, the determination of the Attorney General is generally accepted by the courts. In terms of the presumption of validity of ballot measures, so statutes that are enacted by the electorate through the power of initiative are presumed to be valid. The courts have said, just like the legislature's statutory enactments are presumed valid, so too are measures adopted by the voters. The voters' power to decide whether or not the legislature can amend or repeal initiative statutes is absolute, and it includes the power to enable legislative amendment subject to conditions that are attached by the voters in the ballot measure. The courts have also explained for us that the electorate's legislative power is generally coextensive with the power of the legislature to enact statutes. The legislature is not the exclusive source of legislative power. The Constitution also includes the people's power of initiative and referendum. So that means that the court's role in reviewing an initiative measure is to ascertain and give effect to the electorate's intent, guided by the same well-settled principles that the courts use to give effect to the legislature's intent when the courts review enactments by the legislature. Again, the courts have said they don't pass upon the wisdom, expediency, or policy of those enactments by the voters any more than they do regarding the enactments by the legislature. Remember that the Constitution and the courts note that the initiative and referendum powers are reserved powers. What does that mean? They are not rights granted to the people, they are powers reserved by them in the Constitution. So the people's reserved power and initiative is generally viewed as greater than the power of the legislative body. While the legislative body cannot bind future legislatures, a ballot measure, unless expressly providing otherwise, cannot be amended or repealed unless by a vote of the electorate. And as a result, the exercise of the initiative power by the people can in fact bind future legislative bodies. If doubts can reasonably be resolved in favor of the use of the people's power of initiative and referendum, then the courts will preserve it. Statutes and constitutional provisions adopted by the voters, again, must be construed liberally in favor of the people's right to exercise those reserved powers. What is a revision versus an amendment? Remember, the California Constitution allows the people to amend the Constitution, but not revise it. So, in order to constitute a qualitative revision of the state constitution, which again cannot be validly enacted by voter initiative, a constitutional measure has to make a far-reaching change in the fundamental governmental structure or the foundational power of the branches of government. Although the initiative process may be used to propose and adopt amendments to the Constitution, that process is prohibited from being used to revise the Constitution. In determining whether a state constitutional provision is an amendment or a revision, the courts examine both quantitatively and qualitatively the effects of the measure on California's constitutional scheme. In terms of approval, under California law, once an initiative measure is approved by the voters, the measure becomes a duly enacted constitutional amendment or statute. Interpreting a statute by the courts, they have said that the first task in construction of an initiative is to examine the language of the statute enacted as an initiative or the constitutional language, giving their words their usual ordinary meaning. And in interpreting a voter ballot measure, the Supreme Court applies the same principles that govern their construction of a statute. In construing that language, the courts have said that statutory language enacted by a voter initiative is construed in the context of the statute as a whole, as well as the overall statutory scheme in light of the electorate's intent. When statutory language enacted by voter initiative is ambiguous, then the courts refer to other indicia of voter intent, particularly the analyses and arguments contained in the official ballot pamphlet. In reviewing by the courts, a statute that governs the process by which a proposed ballot measure is submitted for public comment, which specifies that any amendments must be reasonably germane. This doesn't preclude any substantive amendments. Rather, the ability to submit comments is part of the overall broader public forum process. And the comment period is intended to allow members of the public to suggest amendments or even correct flaws in a proposed ballot measure. Turning now to the referendum. The definition is that the referendum is the power of the state's electors to approve or reject statutes or parts of statutes, with four exceptions: urgency statutes, statutes calling elections, statutes providing tax levies, and statutes providing appropriations for the usual current expenses of the state. And that's because those four types of statutes go into immediate effect rather than January 1st following enactment. A referendum measure is proposed by presenting to the Secretary of State within 90 days after the enactment date of that statute a petition that is certified to have been signed by electors equal to 5% of the votes for all the candidates for governor in the last gubernatorial election. And that petition asks that either the entire statute or a specified part of the statute be submitted to the electors. In the case of a statute enacted by a bill passed by the legislature on or before the date the legislature adjourns for a joint recess to reconvene in the second calendar year of the biennium session, the petition cannot be presented on or after January 1st unless a copy of the petition is first submitted to the Attorney General. The Secretary of State submits the measure at the next general election, held at least 31 days after it qualifies, or at a special statewide election held prior to the general election. And just as with an initiative, the governor may call a special statewide election to vote on a measure, a referendum measure. Generally, in California, the people have the right to approve or reject statutes or parts of statutes, like a number of other states with direct democracy. Now, historically, most referendum efforts have either failed to qualify for the ballot or they've been rejected by the voters at the statewide ballot. An important note is that the filing of a valid referendum petition challenging a statute actually stays the implementation of that statute, and it is delayed until after the vote by the statewide electorate. Proposing a referendum can be done to approve or reject, but it is reject in almost every instance when it's used. Again, the entire statute or parts of a statute. And don't forget those four types of statutes that are not subject to a referendum. In terms of the effective dates, an initiative measure or referendum approved by a majority of votes cast takes effect on the 5th day after the Secretary of State files the statement of the votes at the election at which the measure has been voted on. This is the same for an initiative and a referendum. Again, the referendum, where it's filed against a part of a statute, the remainder of the statute is not delayed from going into effect. It goes into effect pursuant to constitutional provisions, which is January 1 of the following year, following enactment of the statute. But if that part of the statute is subject to a valid referendum petition, then the part of the statute is held in abeyance. The process is basically the same for an initiative and a referendum. First, the referendum petition before signature gathering is submitted to the Attorney General, who prepares a title and summary as provided by provisions of the Elections Code. And just like an initiative, a referendum is completed by presenting that valid referendum to the Secretary of State. The difference is the 90-day period. For a referendum, it must be submitted to the Secretary of State within 90 days after the enactment date of the statute. A referendum can qualify for the statewide ballot up to 31 days before an election. Since July of 2011, referendum measures, just like initiative measures, appear only on a general election ballot. They cannot appear on a primary ballot, usually June, or in a non-presidential year, and in a presidential year in March. Once the petitions for a referendum are filed with the county elections officials, the offices of the Registrar of Voters have 8 working days to determine a raw count of the signatures submitted and report those findings to the Secretary of State. And then the Secretary of State certifies the petition based upon the signatures that have been collected and submitted. Now, once the referendum petition is on the ballot, the law is repealed if voters cast more no votes than yes votes on that referendum. And as I've mentioned, the referendum takes effect on the 5th day after the Secretary of State files the statement of the vote. In terms of local measures, initiative and referendum powers may also be exercised by the electors in cities and counties. And these are under election code provisions that the legislature has enacted. Now, this doesn't apply to cities or counties that have a charter. A city or county initiative measure may not include or exclude any part of the city or county from the application or effect of any of its measures, just like a statewide ballot measure. Also, a city or county initiative measure can't contain alternative or cumulative provisions where those provisions would become law depending upon casting a specified percentage of votes for or against the measure. Again, that's the same at the state level as well. Now, what are some key cases related to the referendum process? Here, the first one is the source of the referendum power. Of course, it is found in Article 2 of the state constitution. The courts have said the source of the state's electorate power to exercise the referendum is that constitutional provision. And it's limited to legislative acts. So the power of referendum can be invoked only with respect to matters which are legislative in character rather than administrative. How have the courts defined the power of the referendum? They say that it's the power of the electors to approve or reject statutes. It's not the power to repeal a legislative act. Neither state statutes nor local ordinances subject to referendum go into effect during the time permitted for the filing of a referendum petition. A legislative act subject to referendum cannot be effective before the power of the referendum can be exercised by the voters. And again, the courts have said that a municipal referendum can review only legislative decisions, but not matters that are strictly executive or administrative in their nature. As I mentioned earlier in the initiative, but I will state it here again, the courts have defined the differences between an initiative and a referendum. They've said that the initiative allows voters to propose new legislation, but in contrast, the referendum permits voters to reject legislation that has already been adopted by the legislature. In terms of reapportionment statutes, there is a prohibition against proposing referendum measures to approve or reject statutes calling elections, and the courts have said these did not apply to referendum petitions challenging reapportionment statutes. In terms of court proceedings on referendum measures, because constitutional provisions reserving the referendum power to the people are self-enacting, the courts may properly devise procedures necessary to protect that power when the appropriate legislative body fails to establish procedures. And the referendum is the means by which the electorate is entitled, as a power reserved to it under the Constitution, to approve or reject measures passed by a legislative body. What happens when the referendum power is abrogated? Well, the courts have explained that the scope of the referendum power is generally treated as coextensive with the scope of the legislative authority. As a result, any legislative decision made by a representative body is subject to referendum. But a referendum may only review a legislative decision, not matters, the courts have explained, that are strictly executive or administrative. There are two instances in which the power of referendum will be found to have been withdrawn. The first is when there's a definite indication by the legislature that it intends to preempt the discretion of a local legislative body to legislate. Second is when the legislature, rather than preempt local legislative action, delegates legislative power to a local governing body to indicate the legislature's intent that it is precluding the citizens' otherwise coextensive right of referendum. And the courts have determined that in deciding whether the legislature has abrogated its right of referendum, the mechanical consideration of relevant factors are found to yield in favor of finding against preclusion was not the legislature's intent. The legislature has been deemed to not be able to reduce the people's power of referendum, as you might imagine. The courts have said that the legislature cannot reduce the referendum power reserved to the people by either enlarging or increasing the type of legislation which can become effective immediately. That is only provided for in the Constitution. How about legislative versus administrative acts? Well, first, in that definition, remember the referendum is limited to the operation of adopting or rejecting legislation that's already been enacted. So, for purposes of determining whether acts are legislative and thus subject to referendum, or whether the acts are administrative and not subject to the referendum process, acts that constitute a declaration of public purpose and make provisions for ways and means of its accomplishment are generally classified as calling for the exercise of legislative power. Acts of administration are those necessary to carry out legislative policies and purposes that have already been declared by a legislative body. Again, limitation to legislative acts, although powers reserved to the people of initiative and referendum are to be liberally construed to uphold the powers whenever it's reasonable to do so, the people may involve the power of referendum only regarding legislative matters. In turning to recalls, how are these defined? The California Constitution defines a recall as the power of the electors to remove an elective officer. Recall of a state officer is initiated by delivering to the Secretary of State a petition alleging reason for that recall. What's interesting is that the sufficiency of that reason is not reviewable. Now, the proponents here have 160 days to file the petitions that are sufficiently signed by electors. The state's electors have the power to remove an elected officer. And again, that begins with the delivering of the petition. Further on the process, the petition to recall a statewide officer must be signed by electors first, equal in number to 12% of the last vote for that office, and for signatures from each of 5 counties, equal in number to 1% of the last vote for that office in that particular county. Now, that's for the statewide officers. For recalling senators, assembly members, or Board of Equalization members, or judges of appellate courts or trial courts, the signatures must equal in number 20% of the last vote for that office. And the Secretary of State is specifically required to maintain a continuous count of signatures that have been certified for a particular office recall. An election to determine whether to recall an officer and, if appropriate, to elect a successor is required to be called by the governor, and it has to be held not less than 60 days nor more than 80 days from the date of the certification that there is a sufficient number of signatures on that recall petition. So when is the recall conducted? A recall election is conducted within 180 days from the date of certification of sufficient signatures in order that the election may be consolidated with the next regularly scheduled election occurring wholly or partially within that same jurisdiction. Now, that is, if the number of voters eligible at that next regularly scheduled election equal at least 50% of all the voters eligible to vote at the recall. What's the result of the recall? If a majority vote on the recall question is to recall the officer, then the officer is removed immediately. And if there's a candidate, the candidate who receives a plurality of the vote, not 50% plus one, but the plurality, becomes the successor to the office. Now, note that the officer may not be a candidate, nor can there be any candidacy for an office that's filled pursuant to an appointment by the governor. In terms of the petitions, again, the 160-day requirement for the signed petitions and that 12% or 20%, depending on if it's a statewide official, 12%, 20% for senators, assembly members, and BOE members. Remember that because there's nothing on direct democracy in the federal constitution, there is no right to recall U.S. senators or U.S. House of Representative measures. If a majority again votes to recall the officer, then the candidate who receives the plurality succeeds to the office. A state officer who is not recalled must be reimbursed by the state for the officer's recall election expenses that are quote unquote legally and personally incurred. The other prohibition or limitation is that a subsequent recall may not be initiated against that state officer until at least 6 months after the prior election. The courts in California have determined that the legislature has been granted plenary authority under the Constitution in Article 2 to provide for recall elections in this state. Constitutional office recalls. The state constitution says that if the governor is subject to a recall petition, then the recall duties specified in the Constitution are performed by the lieutenant governor. In a similar vein, if the Secretary of State is subject to a recall petition, then his or her recall duties are then performed by the state controller. As I mentioned, the courts have said, pursuant to the Constitution, that there's reimbursement for unsuccessful recalls, and it's for legally and personally incurred expenses. For local officials, again, the Constitution says that the legislature shall provide for the recall of local officers. Now, counties and cities who have charters, they can provide for recall, and they are exempt from these provisions of the California Elections Code. So that's sort of the legal basis of the three forms of direct democracy here in California. Again, most of these provisions are set forth in Article 2 of the California Constitution.